Hey guys, we're on module 4, it's dealing with federal programs. There's a lot of reading that goes on with this week. Therefore, I've decided there's not going to be an assignment. If you have some time, you might work on your case briefs, the 2 case briefs that are the final assignment. But as far as having to have a written assignment for this week, you won't have to have one. I do want to highlight a couple of things, particularly as it relates to special education and your job as a principal as it comes to special education. So if you'll just bear with me a little bit, let me see if I can get to that. So here we are, special education. There's just a few things I just want to touch base with you on and make sure that you picked up either from the reading or maybe from your personal experience. Here's the deal. If you weren't a special education teacher, then sometimes the things that special education requires for a school administrator, they just don't make sense maybe, or maybe it's the fact that you don't have a real appreciation for what the requirements are. But special education in public schools is a result of a law, and that law is the Individuals with Disabilities Education Act, or IDEA or IDEA. You guys read about that in your chapter in your reading, so I don't necessarily want to go through all of that, but I do want to highlight some things. I want to bring out some practical examples. So there's 6 pillars related to IDEA. First one is the idea of an individual education plan. I'm going to talk more about each one of these, but the IEP, the developing a plan for each individual student, the pillar of free and appropriate public education. That basically means that we have to provide special education services and related services for free. There's been multiple Supreme Court cases on that, and it continues to be that the public school is required to provide that for the students for free. Least restrictive environment. This is the fact that we need to try and educate our special education students as much as possible in a mainstream environment with other students, with non-special ed students. Appropriate evaluation. The whole idea here is that the evaluation is proper and that it fits the diagnosis. We'll talk some more about that. Parent and teacher participation in the decision making. This is where you have your IEP teams. In Texas, they call it an ARD committee, Admission, Review, and Dismissal Committee. In Louisiana, they may call it something different, but basically this is the team that by law has to get together to create an individual education plan for the student. That team must include the parent and the teachers. And then finally, the procedural safeguards. So these are the 6 pillars of IDEA. Now, let me just quickly on procedural safeguards. Procedural safeguards are all the papers that your special ed directors and your special ed teachers are having you sign and the notices that they're going to send out. So it's incumbent upon school principals to understand that we don't just do these things willy-nilly. They're not just done just because we want lots of paperwork to sign, but they're actually done because they comply with the law. So let's look at the individual education plan. First thing you need to understand is that the court has determined that the individual education plan, the IEP, is absolutely the centerpiece for the entire IDEA program. And it's important then that we, as school administrators and special ed administrators and teachers, take those IEPs seriously. And I know how difficult it is as a regular ed teacher to have to be implementing a special ed student's IEP in a regular ed classroom when they've been mainstream. But I'm just telling you that there's no choices here. The IEP has to be developed cooperatively and it has to be administered. You'll see even the 11th Circuit has said this, that it is absolutely the basis for the students' education. We must develop a system that meets the unique needs of each individual student. We'll talk some more about the IEP team, but it's important that as a school principal that you emphasize continuously the importance for your teachers to know and then to follow the individual education plan for each one of these students. Free appropriate public education. So here's what that means. Free appropriate public education is defined as special ed and related services that do these four things. First, that's provided at public expense, under public supervision and direction, and without charge. That's where it's free. That it meets the standards of the state educational agency, that it includes an appropriate preschool, elementary, or secondary school education, and that it is provided in conformity with the IEP. We can't charge students for providing them these services, nor can we deny a student the services that their IEP says they need, just based on the fact that it's expensive or that we can't pay for it. And in fact, the court has ruled regularly that a public school must pay if a service is not available through the public school, then the public school has to pay for that service to be provided by whatever organization is able to provide it. Therefore, if you have a student who is visually impaired, who's blind, they may not actually go to your school, but your school's going to pay for that service because it's a free, appropriate public education. So it says that each IDEA, the statute, includes some requirements that schools must provide each disabled student. And these things that they must provide. They must provide an education that is designed to meet the unique needs of each student. That it provides access to the general curriculum to meet the challenging expectations established for their children. That it is provided in accordance with the IEP, and that it results in an educational benefit to the child. Now, recently, and we'll talk about that here in just a few minutes, that's been the subject of court cases. What does an educational benefit mean? The next pillar of IDEA is least restrictive environment. So simply put, the least restrictive environment is the environment most like that of all the rest of the students, the regular ed students that are in the school. And it's based off of the special ed students' ability to be successful. So in your meetings, the meetings that you have, you will be talking about the placement of these students. Can they be successful in a regular ed classroom? So the court in 1989, Fifth Circuit Court, but it's been used as a precedent. The Fifth Circuit Court in 1989, case of Daniel versus State Board of Education, said there's two questions that we as school administrators and public school officials have to answer. The first one is, can we provide an appropriate education in a general ed classroom with the use of supplemental aids and services? Will that provide that student, that one student, the opportunity to be able to be successful? And then secondly, that if a student is placed in a more restrictive setting, i.e. into a special education room, resource room is what we used to call it, then is the student integrated into the regular ed to the maximum extent appropriate? So I've been in schools where we've had quadriplegics who were in regular education classes, students that we had to feed, We had to change their diapers on a regular basis. But those students were in, especially in our elective classes, were in regular ed classroom because we were trying to put them in the least restrictive environment. Now, a lot of their core classes, the core academic classes, might have been taken care of in a different way. But here's the deal. Each one of those kids deserves to be educated in a classroom with other students, non-handicapped students, who would be their peers. Then the fourth peer is an appropriate evaluation. So Louisiana has these special ed designations. So you can see these here. These are all the different designations that can be assigned to a special ed student in Louisiana. And your school district has an assessment or an evaluation methodology. So while the actual procedure may change from one school to the next, the state law, Louisiana state law, says that it has to comply with these 5 things. First, you have to use a variety of assessment tools. So it can't just be one assessment. So it has to use a variety of assessment tools. Secondly, the assessment that's used for the evaluation cannot be discriminatory, and it should be provided in the child's native language if possible. Third, it should be administered by a trained and knowledgeable professional. Fourth, the assessments should match the specific educational needs of your child. And then lastly, it should have everything it needs to be able to identify all of your child's special ed needs. A parent, after an evaluation has been completed, has the right to obtain an independent evaluation. And then the committee would have that opportunity to take into account both of the evaluations. The committee or IEP team, by law, is required to include at least the parent and teacher. And so I looked up in Louisiana what the law was in Louisiana. So here's the law in Louisiana. The IEP team has to include the child's parent or guardian, the child when appropriate. I assume that has to be based upon their age. I know in Texas, once a child turns 17, then they become the parent or guardian. They usually are included in the IEP meetings beginning in junior high, but that would probably be a local decision. A special ed teacher or provider, a general ed teacher. Now, in Louisiana law, it says when appropriate. I'm not sure what that means. In Texas, we always had to have a general ed teacher. A representative of the local education agency who is knowledgeable about instruction, curriculum, and resources. And then in the law, it says other people whom you or the local education agency wish to invite, you being the special ed, the parent of the special ed teacher. So the state determines the members of the IEP team. It doesn't say on here that a school administrator had to be there, but in my state, in Texas, we had to have a member of the IEP team, had to be someone who could allocate and approve resources. Therefore, in my state, the administrator was required to be at each one of these IEP meetings because that's the only person by policy that could allocate the school district funds. That may be the same way for you, or it may not be. You'll have to ask your principals if they are required to attend the IEP meetings. But it would make sense that an administrator be a part of this process if the IEP is going to require the school to expend additional funding, whether that's hiring an aide for a student or placing a student in another setting, in a private school or in a special school, designed specifically for them. And then procedural safeguards. So these procedural safeguards that your special ed directors come to you with are not just they're not just more paperwork. They're not just trying to cover themselves. They're actually trying to adhere to and follow the IDEA law and guidelines. So these are all these are all required by law. These are things that are required by the law, by the federal law, that we provide to the parents. Access to the records, parent participation. That means that the parents are going to participate in any and all meetings. They're going to be a part of any decisions that are made about the educational program being offered to their child. Prior written notice, we have to give that to the parents. Anytime anything's going to change in the student's IEP or there's a proposed change. The procedural safeguards notice, they have to receive a written copy. What I've found is that most special ed directors want that to happen at the very least every year, and at the very worst, every time there's a meeting. It has to be in an understandable language. Therefore, if the IEP meeting is with a child or parents that speak Urdu, then it's the obligation of the school to find a translator who can translate the meeting. Informed consent papers. This before any evaluations or services are provided. The parents have to be informed and they have to agree. The stay put rights. If a parent disagrees with the school's decision, then the school basically has to keep the student in its current program until either the parent agrees or until an appeal process works its way. Due process. This is where if a parent has a dispute with the school about their child's placement or the teaching, then they're offered due process. It's their ability to tell their side of the story. It's done in a very formal, almost court-like action. Civil action deals with the fact that we have to inform the parents that they can file a civil lawsuit against the school if they feel like that their rights have been violated. And then the mediation paperwork is so that the parents understand that before we go to trial, we'll attempt to do that. We will attempt to come to a resolution through a process called mediation. So there's a couple of things, guys, I need you to be real cognizant of as school principals. And one of those is the student discipline situation with special ed students. So one of the things that I used to always ask when when a teacher or an assistant principal would bring me a discipline referral, one of the first questions I always asked is the student in special ed? And the reason that I ask that question is because there's a legal requirement. If a student is in special education, there's a legal requirement that we can get the IEP team together and that we conduct an assessment or determination. They call it a manifestation determination. So at this meeting, then we basically answer two questions. The first one you see there was the conduct caused by or had a direct and substantial relationship to the child's disability. So your book gave an example, I think, of maybe an autistic child that blurted out in class, screamed out in class, and the teacher wanted to discipline them for disrupting the class. So did their blurt, did their scream or their yell, did that have anything to do with their disability? If it did, then you cannot administer discipline to that child for that purpose. Now, there's certainly special ed conditions that don't lead students to hitting other students or stealing things. I mean, just because you have a manifestation determination meeting doesn't mean you're going to determine that the behavior was a manifestation of the disability. But you have to have the meeting. The meeting has to include the parent. and it has to include the teacher, and you have to go through a process. So the second question is, was the conduct a direct result of the local education agency's failure to implement the IEP? So not only do we ask the question, did the child's disability cause the behavior? But then secondly, we have to look at, were we implementing the IEP appropriately? And if whatever teacher was not implementing the IEP appropriately, it really doesn't matter what the student did. We have to excuse, if you will, that behavior because we were not implementing the IEP appropriately. So if either of those two questions can be answered yes, then the IEP team can create a couple of different, they can go through a couple of different things. They can do a assessment of behavior. It's called a functional behavior assessment, to determine what are the triggers, what are the things that are causing the behavior, whether it is where we have a student sitting in class, the people that he's around, maybe the fact that it's a large class. Are there things that we can do in this after we hear this assessment to decrease the likelihood that there are going to be behavior outbursts? And then the last thing is a behavior intervention plan, or a BIP. And SPED people will talk about this as a BIP. So you work together with the student, the parent, with school psychologist, whoever you need to work together with to create a behavior intervention plan so that you can help the student be able to learn how to deal with the whatever the circumstances are that cause that. Now, very quickly, I'll give you some practical advice. See if I can get back to it. Oh, I think I've missed it. Oh, yeah. Okay, right here. So these are the different special ed categories. If you look at autism, deaf blindness, you can see those. One of the things that I found, practical advice from a school principal, is that a student who is diagnosed as emotional disturbance, so they have some kind of an emotional disturbance. If they were a discipline issue and we had to go to that manifestation determination meeting, the fact that their diagnosis was emotional disturbance meant that there was almost everything that they could do, every behavior could be considered a manifestation of their disability. Now, that doesn't completely tie your hands, but you just need to know that if you have a student with a diagnosis of ED and they're a discipline issue, then you're going to have all of your ducks in a row, cross your T's and dot your I's to make sure that you determine as a school principal that student's emotional disturbance didn't cause their behavior. Okay, for whatever reason. So okay, and then the second thing is just the state put provisions. If a parent disagrees with your decision in a behavior or even in a special ed placement, then you need to know that your state law is going to determine what the length of time is for your state put provisions and the reasoning behind those provisions. Now, most states, and I think Louisiana will be the same, is if you as a school principal feel that the student is a threat to the school or the other students, will allow you to change their placement for a certain amount of time while you're waiting for the manifestation meeting to be able to take place. You'll have to check with your local law, but just know that it's not just as easy as throwing a kid in ISS or suspending them or whatever. You can protect the rest of your students. Now, I want to talk to you real quick about the evaluation, the special ed evaluation, because all of us, and this also, by the way, is in the law, back in the old days, and some of you may be able to remember this, back in the old days, the way that a student was determined to be eligible for special education is if there was a deficit between their IQ and between their ability or what they were doing. So if a student had an IQ of 80, and they were performing at 80, they didn't qualify for special ed. But if they had an IQ of 100 and they were performing as an 80, then there was a discrepancy, there was a gap. And the size of that gap indicated whether they would qualify for special education. So this became problematic with legislators and with the Congress, and so and quite frankly with educators, and so so they implemented a response to intervention process, and that's what we use now to try and determine whether a student qualifies for special ed, or at least qualifies to be to go through a special ed evaluation. So here are the core assumptions of RTI. You guys use it in your schools now, I'm sure. It's in federal law. I don't know if you call it RTI, but this is what you do. And it requires you to go through a multi-tier process before a student can be recommended for special ed evaluation. Now, the reason I tell you this is because regular ed teachers don't understand this process and the time this required, and that takes place for a student to be able to go through all 3 tiers of the RTI process and all the interventions that we try before we assign them to special education, before we evaluate them, that have to take place so that we can make sure that the student has to be placed in special education. So just be aware that RTI is part of the IDEA law, and it is designed to make sure that we've basically tried everything that we could before we assign a student to special ed. So here's some practical advice. Understand that the SPED students are your students. You're the school principal. Sometimes people get talking to special ed teachers and they say their students. Those are your students, and your students did this and your students did that. Well, the SPED students, guys and gals, are your students. All the students are yours. So you just need to make sure that you protect them and that you support them just like you do the general ed kids. Understand that the IEP committee is more powerful than a school board. It's more powerful than a superintendent. And quite frankly, it's more powerful than a state legislature. The decisions that are made by the IEP committee are decisions that are protected by federal law. And the IEP committee can, if they want to, require the school board to expend more money, can require a superintendent to hire additional staff, and can even require a state legislature to adhere to change a state law. So it is very important. As a school principal, you need to understand that you're going to spend a significant amount of your time administering special ed issues, whether that is scheduling, if you have to attend the IEP meetings, the fact that special ed student discipline takes longer, because you will spend a larger percentage of your days and of your time administering special ed than you have percentage of special ed population. Understand that parents, as their student is in special ed, they begin looking for folks that can help them. And there is a whole cottage industry of special education parent advocates, most of whom are very, very are usually former school employees, and they actually do a pretty good job. But there are some parent advocates that are really out there to gouge the school. And so just be aware, if a parent is bringing an advocate with them, that doesn't mean that you need to get an attorney or anything like that, but it does mean that you need to make sure that you are conducting the meeting appropriately. You as a principal will want to be at that IEP meeting, even if you are not required to be at the others. You want to be there because parent advocates oftentimes ask for, things that maybe are not necessary in order to administer the child's IEP. And if the IEP calls for a service, you as a school principal cannot refuse them. So again, very important for you to be a part of those IEP meetings and have an understanding with your special ed folks. So I wanted to share with you, actually the court case was in 2016, was heard in 2016, but the Supreme Court issued a decision in March of this year. And in the case, Andrew F. versus Douglas County School District. Douglas County School District is a Colorado school district. And Andrew's parents had removed him from his local public school because he was making very little progress. And they actually placed him in a private school. And they said he made lots of progress, significant academic and social progress. In 2012, Andrew's parents filed a complaint with the Colorado Department of Education to recover the cost of tuition at the private school. The cost of tuition at that school, $70,000 per year. So the lower courts upheld the school district and basically said that the school district didn't have to pay it. So the argument came down to the Andrew, while he was a student in the public school, he made progress, but he didn't make significant progress. So it really came down to what is the requirement, legal requirement in the law about what kind of academic progress that a student has to make in our special ed program. So here are some quotes from Chief Justice John Roberts. And you can see he says that it has to be more than what de minimis or minimal progress from year to year. So it can't be, and de minimis had been the legal standard before this. I think Justice Roberts was pretty sure about him, about his ideas. Says that the educational program must be ambitious and that every child should have a chance to meet some objectives. Now, here's the deal, guys. This was an 8-0 decision by the Supreme Court. So advocates and parents say that this decision is going to significantly expand the rights of SPED students in the United States. And it creates a nationwide standard for special education. And it empowers parents as they advocate for their children. And it's certainly legally, before this, the standard of de minimis or minimal progress, that as long as they were making some progress, that was enough. Justice Roberts says it has to be significant. It has to be ambitious. It has to be challenging. Challenging objectives. The student has to make some of those kinds of progress. So this is going to change special education and the way that we legally change special education and the way that we administer the program. So one last thing I want to touch on is Section 504. Section 504 is different from IDEA. Section 504 comes from the Rehabilitation Act. And this is what Section 504 says. IDEA has a list. You saw the list of qualifying conditions. student has to qualify for IDEA based off of that list of qualifying conditions. Section 504 has no list. It just says disability. That because of their disability, a student cannot be excluded from participating. By the way, Section 504 works for your employees as well. So the regulations for 504, well, let me back up and say this. Every student who qualifies for special education, who qualifies for IDEA, also qualifies for Section 504. The inverse of that is not true. Every student is 504 does not qualify for special ed. In schools, we serve through Section 504, we serve a lot of students who don't qualify for special ed, but they may have another disability like ADD or ADHD. But we're still federally required to provide them a free, appropriate public education. We're required to provide, to assess them, to put them in that program, to provide assistance, individual student assistance, so that they can be successful in the program and can provide, whatever related services that they might need. We have to provide that even though they don't qualify for IDEA. Now, at least right now, the formal requirements that are required in your IEP meetings are not required for Section 504, but you still have 504 meetings. You're not required to do the procedural safeguards at least to the same extent, but nonetheless, every student who has a disability, as defined by Section 504, is still required to be provided assistance, modifications, if you will, or help so that they can be successful in school. So there's a lot more that was in the book. I'm not going to cover a whole lot of the new federal law because we quite frankly don't know everything to do with every Student Succeeds Act. Every state is still submitting plans to the federal government. Suffice it to say that we don't have to do highly qualified teacher reports anymore. It doesn't look like there's going to be an accountability piece, or at least not as significant accountability piece with the Every Student Succeeds Act. I think they're trying to push that down to the states, which I think is appropriate and where it belongs. Nonetheless, there was some good information in Chapter 11 that you read. So that's it for this week, guys. Enjoy your week. I hope this wasn't terribly boring, and hope that you got something out of it. And I look forward to talking to you soon.